I've sentenced thousands of people in my career. Felons, fraudsters, petty criminals, and every shade of wrongdoer in between. I've presided over cases that have made headlines and cases so mundane they'd cure insomnia. But I can say, with absolute certainty, that I never, ever thought I would have to leverage the full weight of the state's judicial system against my next-door neighbor because she had a fundamental disagreement with the structural integrity of my mailbox. So, settle in and maybe pour yourself something strong. Drop a comment and let me know where you're watching from, because you're about to hear how a dispute over postal receptacles led to a suspended license, a hefty fine, and a short, sharp stay in a county-funded correctional facility. This one gets a little crazy. It all started, as these things so often do, with a move. After 40 years on the bench, 30 of them in the state superior court, I transitioned to senior status. It's a form of semi-retirement for judges, where you still hear cases but on a reduced schedule, filling in where needed. It afforded me the time to finally leave the city and buy a home in a quiet, leafy suburb called Okavena name that promised tranquility but delivered a tempest in a Tiffany teacup. My wife Eleanor had passed a few years prior, and the big house was filled with more memories than I could manage alone. This new place was smaller, with a lovely garden that backed onto a small preserve. It was supposed to be my haven of peace, a place to read history books, tend to my roses, and enjoy a quiet old age punctuated by the occasional tort case. The key words here are supposed to be. The problem in Oakhaven had a name: Brenda Millwood. She was the thrice-elected, unopposed president of the Oakhaven Homeowners Association. Brenda drove a pearl-white Cadillac Escalade, wore designer tracksuits that cost more than my first car, and wielded the HOA's book of covenants and restrictions like a scepter. She was a woman who had mistaken control for purpose. In the first week, I received a notice that my garden gnome, a whimsical gift from my daughter, was aesthetically discordant with community standards. The gnome, whom I had affectionately named Justice Ginsburg, was summarily removed to the garage. A week later, another notice, this time about the precise shade of beige on my trim. It was apparently oyster white, when the bylaws clearly specified eggshell. The difference was discernible only to God and Brenda Millwood. I am, by nature and profession, a patient man. I've listened to 8-hour depositions about defective sprockets. I've endured sovereign citizen arguments that defy all logic. I could handle Brenda. I repainted the trim. I complied. I smiled politely when she'd patrol the neighborhood in her Escalade, slowing down as she passed my house, her eyes scanning for any new infraction. My neighbors, a pleasant mix of retirees and young families, treated her with the kind of wary deference usually reserved for unstable dictators or particularly venomous snakes. A retired aerospace engineer named George, who lived across the street, warned me over the fence one afternoon. "She feeds on this stuff, Arthur," he'd said, gesturing vaguely at the neighborhood. "The bylaws are her Bible, and she's the only one allowed to interpret Scripture." The mailbox was my line in the sand, though I didn't know it at the time. The existing one was a flimsy, wobbly metal post left by the previous owners, so I decided to build a new one. Being a man who believes in doing things correctly and only once, I did my research. I consulted the U.S. Postal Service regulations on height, setback from the curb, and mailbox size. I then went to the county records office and pulled the original plat maps and local ordinances regarding roadside structures. I designed a handsome, sturdy enclosure of red brick around a regulation-sized, USPS-approved metal mailbox. It matched my house perfectly. It was precisely 42 inches tall and set back 8 inches from the curb, exactly as specified. It was, in short, the most legally and regulatorily compliant mailbox in the history of Oakhaven. It was also, admittedly, very solid. I'd built it to last, not to self-destruct upon contact with a 2.5-ton luxury vehicle. That, as it turned out, was its unforgivable sin. The fateful day was a Tuesday. I was in my study, reviewing briefs for an upcoming appellate case, when I heard the screech of tires followed by a percussive crunch that sounded expensive. I went to the window and saw it. Brenda's pearl-white Escalade had somehow mounted the curb and was now intimately acquainted with my new brick mailbox. The front passenger side bumper was caved in, a headlight was shattered, and the grille looked like a sad, metallic frown. The mailbox, to its credit, was largely unscathed. A few bricks were chipped, a bit of mortar was powdered, but it stood defiant, a monument to proper construction. I walked outside, my first instinct being to see if she was all right. I should have saved my concern. Brenda flung open her driver's side door, her face a mask of incandescent rage. She wasn't holding her neck or checking for injuries. She was pointing a perfectly manicured finger at my mailbox. "What is the meaning of this?" she shrieked, as if I had somehow willed the structure to leap into her path. "Brenda, are you okay?" I asked, keeping my voice even. "Okay? Do I look okay?" She gestured wildly at her wounded SUV. "Look what your fortress did to my car. This is going to cost a fortune." "It appears you drove into it," I stated, observing the tire tracks that made a neat arc from the middle of the street, across the lane, and directly into my property. "I swerved to avoid a squirrel," she declared, an explanation that was as cliché as it was unbelievable. "This thing should have collapsed. A normal mailbox would have bent. It's a hazard. It's a weapon. You built a weapon at the end of your driveway." I stood there, blinking, as the sheer, unadulterated absurdity of her logic washed over me. She was blaming the mailbox for being too well made. She was angry that an inanimate object, which she had struck with her vehicle, had failed to sufficiently sacrifice itself for the convenience of her poor driving. This was a new frontier of entitlement, even for her. A police car eventually arrived, summoned by another neighbor. Brenda gave the young officer a tearful, dramatic account of the heroic squirrel and the malevolent mailbox. I gave him a calm, factual statement and my driver's license. I watched as he handed Brenda a citation, likely for failure to maintain control of her vehicle. The look she shot me could have curdled milk. It was a look that promised war. A suburban beige-on-beige, passive-aggressive war, but war nonetheless. The next day, slid into the slot of my indestructible mailbox, was the first official salvo, an HOA violation notice. The charge? Installation of a non-standard, dangerously reinforced and collision, hazardous mailbox structure. The fine was $200, with a demand for its immediate removal. I read it, chuckled dryly, and filed it away in a new folder I labeled, with a sense of grim foreboding, the mailbox war. The initial violation notice was merely the opening shot in what quickly became a campaign of escalating harassment. Brenda, stewing in a potent brew of public embarrassment and private fury, was not a woman to let a simple traffic citation and a damaged Escalade be the final word. She was determined to prove that she was the victim and my mailbox was the villain. Every few days, a new envelope would appear, each one containing a more stridently worded letter than the last. The initial $200 fine was soon joined by daily late fees. Then came a second violation, this one for failure to cure the initial infraction. The fines were now compounding at a rate that would make a loan shark blush. I responded to the first notice with a polite, formal letter. As a judge, I live and breathe procedure, so I followed hers to the letter. I addressed it to the Oak Haven HOA Architectural Review Committee, which I knew was just Brenda and two other board members who functioned primarily as her echo chamber. In the letter, I respectfully denied the violation. I attached copies of the USPS regulations, the relevant county ordinances, and a printout of the plat map showing my property line and the utility easement. I demonstrated, with surgical precision, that my mailbox was not only compliant, but a textbook example of a properly installed roadside postal unit. I concluded by stating that I would not be paying any fines associated with this baseless claim and considered the matter closed. Of course it wasn't. Brenda's response was to call an emergency meeting of the HOA board. The subject, according to the notice posted in the community clubhouse, was urgent community safety. the proliferation of non-compliant and hazardous structures. It was a thinly veiled public trial of my mailbox. My neighbor, George, called me the evening he saw the notice. "She's trying to turn the whole neighborhood against you, Arthur," he warned. "She's been going door to door, showing people pictures of her car, talking about how a child could have been hurt by your brick monolith." I decided to attend. I wanted to see her perform. The meeting was held in the clubhouse, a room decorated in a style I could only describe as suburban Tuscan tragedy. Brenda sat at the head of a long table, flanked by her two loyal board members, a nervous-looking man named Frank and a woman named Carol, who nodded at everything Brenda said with the enthusiasm of a bobblehead doll. About 15 residents were scattered in the chairs, most looking either bored or apprehensive. Brenda began with a dramatic sigh. "As you all know," she started, her voice laden with faux gravity, "my primary concern has always been the safety and aesthetic harmony of our beautiful Oakhaven. But recently, a dangerous precedent has been set." She clicked a remote, and a large photo of my mailbox appeared on the projector screen, looking rather stately and handsome, I thought. "This structure," she said, her voice dripping with contempt, "was recently involved in an incident that caused thousands of dollars in damages." She then showed a series of glamour shots of her mangled Escalade. "It was an incident where you drove your car into it," I said calmly from the back of the room. Brenda's head snapped in my direction. "I was avoiding a squirrel, Mr. Finch, something a normal, flimsy, community-minded mailbox would have accommodated. It would have bent. It would have yielded. Yours acted like a concrete bunker." An uncomfortable silence fell over the room. People were looking back and forth between us. This was better than cable. I stood up. "Brenda," I said, my tone measured and conversational, "I have already provided the board with documentation confirming that my mailbox is fully compliant with all federal and local regulations. The issue here is not my property. The issue is your driving." Frank, the nervous board member, cleared his throat. "But Brenda, he does have a point about the regulations," he began, before being silenced by a glare from her that could strip paint. "The regulations are a baseline, Frank," she snapped. "We, the HOA, have a higher standard, a standard of consideration, of yielding." The absurdity was reaching new heights. She was arguing for a legally mandated weakness in construction. It was magnificent. I saw George in the corner, trying and failing to hide a grin. I laid my final card on the table for the evening. "The police report cited you for failure to maintain control of your vehicle. Your insurance company, I presume, has reached the same conclusion, as they have already contacted mine to arrange for the minor repairs to my mailbox. This is not an HOA matter. It is a closed traffic incident." The mention of the insurance company sent a murmur through the room. That was a fact Brenda had conveniently omitted from her door-to-door campaign. Her narrative was crumbling. She banged a small gavel on the table. "This is not over, Mr. Finch. The board will take your comments under advisement." The very next week, I was served. A process server, a young man who looked deeply apologetic, handed me a summons. Brenda Millwood was suing me in civil court. She was demanding $7,800 for the repairs to her Escalade, plus court costs and punitive damages for my gross negligence in constructing a public nuisance. The lawsuit was the moment the conflict transitioned from a neighborhood squabble into my professional domain. Brenda had no idea who she had just sued, but she was about to find out. I read the paperwork, a document riddled with emotional language and legally dubious claims, and called a number I hadn't called in years. "Eleanor," I said into the phone, "it's Arthur Finch. I find myself in a peculiar situation. I need a lawyer." Eleanor Davies wasn't just any lawyer. She was the sharpest litigator I knew, a former clerk of mine who had gone on to build a formidable reputation for dismantling frivolous lawsuits. The game had changed. Brenda wanted to play hardball. She had no idea I owned the stadium. Eleanor Davies agreed to meet me at her downtown office the next day. Her firm occupied the top floor of a glass and steel tower that offered panoramic views of the city I had just left. The irony was not lost on me. I'd fled the city's conflicts only to find a more primal version in the suburbs, forcing me right back into the lion's den. Eleanor, a woman whose sharp suits and sharper intellect I had always admired, greeted me with a warm but professional handshake. "Judge," she said, ushering me into a conference room, "it's been too long, though I never pictured our reunion being prompted by a dispute over masonry." I handed her the lawsuit. She read it, her expression shifting from curiosity to amusement, and finally to a look of profound professional contempt. "Good heavens, Arthur," she murmured, setting the papers down. "She's alleging your mailbox committed assault and battery on her Escalade. The legal theory here appears to be that your property had a duty to be more fragile. Who is her counsel?" She flipped to the last page. "Ah, a Mr. Todd Slattery. His reputation precedes him, unfortunately. He's known for throwing legal spaghetti at the wall to see what sticks. This is pure intimidation." "That's Brenda's modus operandi," I explained, recounting the history of her reign. "The gnome, the paint, the emergency meeting. She believes reality will bend to her will if she just complains loudly enough. In this case, she wants my mailbox to have bent." "Well," Eleanor said, a predatory gleam in her eye, "she's about to discover that the law is not as malleable as a cheap aluminum post. We're not just going to defend this, we're going to dismantle it. We'll countersue for malicious prosecution and seek sanctions against her and Mr. Slattery for filing a frivolous lawsuit. My role as a judge, even a senior one, meant I had to be scrupulously ethical. I couldn't represent myself, nor could I be seen to be using my position to influence the case. I was now a client, a defendant. It was a humbling, if educational, experience. "Just guide me, Eleanor," I said. "Tell me what you need. I'll be your most prepared client." "I have no doubt," she smiled. "First, we play by the book. We file our answer. Then, we begin discovery. We will request every document, every email, every text message she has regarding this incident. We want her phone records, the vehicle's black box data if we can get it, and a full record of her driving history. We're going to bury them in paperwork." But I knew we needed more than just a paper trail. We needed a smoking gun. Brenda's entire case rested on the lie that she swerved to avoid a squirrel. We had to prove she was negligent. George, my neighbor across the street, I told Eleanor, is a bit of a technology enthusiast. He has a multi-camera security system that covers his entire property. Eleanor's eyes lit up. "And does any part of it happen to have a view of your driveway?" "It has a panoramic view of the entire street," I said. "I believe he once told me it records in 4K. That evening, I paid a visit to George. I found him in his garage, tinkering with what looked like a Cold War-era ham radio. I explained the situation, that Brenda had actually filed a lawsuit. George just shook his head, a weary look on his face. "That woman," he sighed. "She's the reason God created lawyers. Of course, I'll help, Arthur. Let's go pull the tape." We went into his study, a room filled with monitors displaying various angles of Oak Haven's sleepy suburban lanes. George navigated to the date and time of the incident. And there it was, crystal clear. Brenda's pearl-white Escalade came into frame, driving down the center of the road. There was no squirrel. There was no sudden swerve. Instead, the vehicle simply began a long, gentle, inexorable drift to the right. It drifted across the asphalt, over the gutter, and onto the grass verge. George zoomed in on the driver's side window. Through the glare, you could clearly see Brenda's head was down, and illuminating her face from below was the distinct, bluish-white glow of a smartphone screen. She looked up only a fraction of a second before impact. It was undeniable. She was texting and driving. She had lied to the police, to her insurance company, to the neighborhood, and now, in a sworn legal document, to the court. "George," I said softly, "you may have just ended this." "Happy to be of service," he said with a grim smile. "Send a copy to your lawyer. Let that woman hang herself with it." The next phase was the deposition. This was the moment I was waiting for. It was to be held at a neutral law office. I attended, as was my right as the defendant, and sat beside Eleanor. I remained silent the entire time. My very presence, I knew, would be unsettling. Brenda arrived with her lawyer, Mr. Slattery, looking supremely confident. She wore a cream-colored pantsuit and regarded me with a look of smug pity, as if I were some doddering old man she was about to fleece. Eleanor began the deposition gently, asking Brenda to state her name for the record, to confirm she understood she was under oath. Then, she had Brenda walk her through the incident. Brenda recounted her tale of the heroic, last-minute swerve to save the life of a phantom squirrel. Her voice was filled with conviction. She was a practiced liar. "So, you were fully attentive to the road at all times prior to the squirrel's appearance?" Eleanor asked, her tone placid. "Absolutely," Brenda said firmly. "My eyes were on the road." "You weren't on your phone, perhaps?" Mr. Slattery shifted in his chair. "Objection. Counsel is leading the witness." "It's a deposition, Todd. I can lead all I want." Eleanor shot back without looking at him. "Ms. Millwood, please answer the question. Were you using your mobile phone at or around the time of the collision?" "No," Brenda said, her eyes narrowing. "That's an insulting accusation. I am a very safe driver." Eleanor paused, letting the lie hang in the sterile air of the conference room. She looked down at a file, then back up at Brenda. "So, to be perfectly clear, under penalty of perjury, you are testifying that the sole cause of this accident was an animal in the roadway and not, for instance, you being distracted by an electronic device?" "That is exactly what I am saying," Brenda said, leaning forward with an air of defiance. Eleanor smiled, a thin, dangerous smile. "Thank you, Miss Millwood. I have no further questions at this time." As we packed our briefcases, Slattery approached us. "A word of advice," he said with unearned swagger. "My client is prepared to settle for $5,000. It'll save your client the embarrassment of a trial." I just looked at him. I didn't say a word. Eleanor spoke for me. "Mr. Slattery, the only embarrassment here is going to be yours when you have to explain to your client what happens when you lie under oath. We will see you in court." There will be no settlement. We walked out, leaving him looking confused. The trap had been set and baited. Brenda had walked right in and slammed the door shut behind her. The weeks leading up to the court date were a masterclass in strategic silence. Eleanor filed our witness and exhibit list, which included George's name and a vague description. Video evidence of the incident. It was a landmine buried in plain sight, and Brenda's counsel, Mr. Slattery, either missed its significance or was too arrogant to care. Meanwhile, Eleanor sent a carefully worded letter to the other members of the HOA board, Frank and Carol. The letter outlined the evidence of Brenda's perjury, the frivolous nature of her lawsuit, and informed them that under the HOA's own bylaws, board members could be held personally liable for legal fees incurred through malicious or grossly negligent actions taken in their official capacity. We included a copy of the deposition transcript where Brenda sealed her fate. The effect was immediate. Frank called Eleanor the next day, his voice trembling, insisting he had no idea Brenda had lied and wanted no part of the lawsuit. Carol, through her own attorney, sent a formal letter stating she had voted against the lawsuit in a private session but had been overruled by Brenda. The united front of the Oak Haven HOA was dissolving into a panic-stricken rout. Brenda was alone, whether she knew it yet or not. The day of the trial arrived. It was a bench trial, meaning a judge would decide the outcome, not a jury. We were in a small civil courtroom in the county courthouse, a building I knew intimately. As we took our seats at the defendant's table, I saw a few court clerks and bailiffs do a subtle double-take. They recognized me, of course, but their professional discretion was absolute. I was just another citizen today, a defendant in a petty civil dispute. Brenda and Mr. Slattery swept in. Brenda dressed in what she likely considered a power suit of electric blue. She looked at me and offered a tight, condescending smile. She still believed she was in control. She still believed she was going to win. The presiding judge, Judge Miller, was a no-nonsense jurist with a reputation for efficiency and a low tolerance for theatrics. This did not bode well for Brenda. Slattery presented their case first. It was every bit as flimsy in person as it had been on paper. He called Brenda to the stand, where she repeated her squirrel story with practiced earnestness. He showed photographs of the damaged Escalade and presented a certified estimate for the repairs. His entire argument, when stripped of its bluster, was that my mailbox was unreasonably and dangerously strong. A community is about compromise, Your Honor, Slattery pontificated. And this mailbox? It represents a failure to compromise. It is an act of concrete aggression. Judge Miller listened, his expression unreadable, occasionally jotting a note. When it was Eleanor's turn to cross-examine, the atmosphere shifted. Miss Millwood, Eleanor began, her voice calm and steady, you testified that you were paying full attention to the road. Is that correct? Yes, Brenda said. And you testified, both in your deposition and just now, that you were not using your cellular phone. That's correct. You are aware you are under oath? Of course I am, Brenda snapped, growing irritated. Your Honor, Eleanor said, turning to the judge. At this time, the defense would like to present Exhibit A. The court clerk took a USB drive from Eleanor and handed it to the bailiff, who plugged it into the courtroom's AV system. My neighbor George's security footage filled the large screen on the wall. The video was clear, the quality impeccable. The courtroom was silent as we all watched the pearl-white Escalade drift slowly, lazily, across the road. We saw it mount the curb. We saw the unmistakable glow of the phone on Brenda's face. We saw her head snap up a half-second before the crunch. And then, for good measure, Eleanor had the court technician zoom in, making the image of the phone undeniable. A collective gasp went through the small gallery. Mr. Slattery's face went pale. He looked at his client as if seeing her for the first time. Brenda stared at the screen, her mouth slightly agape. The lie, so central to her identity in this conflict, had been exposed in glorious 4K resolution. Eleanor let the image linger for a moment before speaking. Ms. Millwood, she said, her voice now cold as ice, would you like to reconsider your testimony regarding the squirrel? Brenda was speechless. She just stared at the screen, then at the judge, her face a mixture of shock and horror. I didn't think so, Eleanor said. No further questions, Your Honor. Judge Miller looked down from the bench, his gaze resting on Brenda. The look was not one of anger, but of profound disappointment. Mr. Slattery, he said, his voice dangerously quiet. Do you have anything to add? Or would you like to sit down before you find yourself in deeper trouble? Slattery, looking utterly defeated, mumbled, Nothing further, Your Honor. Judge Miller removed his glasses and rubbed the bridge of his nose. Ms. Millwood, in my 15 years on this bench, I have seen a great many frivolous claims. This one, however, rises to a level of audacity that is, frankly, astonishing. You drove your car into a stationary object while you were, it seems quite clearly, distracted. You then concocted a story and proceeded to harass your neighbor, abuse your position in your homeowners association, and file a lawsuit based on a demonstrable falsehood. You have wasted the court's time and resources. He banged his gavel once. The plaintiff's case is dismissed with prejudice. I am awarding the defendant, Mr. Finch, full reimbursement for his legal fees. Furthermore, I am sanctioning both you, Ms. Millwood, and your counsel, Mr. Slattery, for filing a suit in bad faith. You will pay a fine of $5,000 to the court. And finally, he said, looking directly at Brenda, given the irrefutable evidence of perjury committed here today, and in a sworn deposition, I am referring this entire matter to the district attorney's office for review. We are done here. The gavel struck again. It was over. Brenda sat frozen on the witness stand, her face ashen. The public humiliation was total and absolute. As we gathered our things, I saw her husband, a meek man I'd only ever seen trimming their hedges, rush to her side. He wasn't comforting her. He was hissing at her, his face a mask of fury and shame. The war was won, but the final judgment was yet to be rendered. The fallout from the trial was swift and brutal, a social shockwave that rippled through the quiet, manicured streets of Oakhaven. The story of Brenda's courtroom implosion complete with video evidence and a judge's searing rebuke, spread faster than a grass fire. George, my faithful ally, provided a meticulous, almost gleeful blow-by-blow account to anyone who would listen. The legend of the Mailbox of Justice was born. Within 48 hours, an emergency meeting of the HOA was called, but this time it wasn't by Brenda. It was forced by a petition signed by over 2/3 of the homeowners. The meeting was a public spectacle. Brenda didn't even show up. Frank and Carol, the last of her board allies, resigned on the spot, reading from prepared statements that effectively threw Brenda under the bus they claimed she had parked them in front of. A vote of no confidence was held, and Brenda was unceremoniously stripped of her presidency in absentia. George was, to his mock protest, elected as the new interim president, on a platform of reading the bylaws once and then putting them in a drawer. A new era of benign neglect was dawning in Oakhaven. But for Brenda, the civil court disaster was only the beginning. The district attorney's office, prompted by Judge Miller's referral, moved with surprising speed. The evidence was, after all, gift-wrapped. They filed 2 criminal charges against her, 1 count of perjury, a felony, for lying under oath in her deposition, and 1 count of filing a false police report, a misdemeanor, for her initial tale of the heroic squirrel. The Oakhaven Police Department also reissued her traffic citation as a more serious reckless driving charge based on the video evidence of her texting. Brenda Millwood, the queen of covenants and restrictions, was now tangled in a system whose rules were not open to her interpretation. Months passed. My life returned to the peaceful rhythm I had sought. I rebuilt the few chipped bricks on my mailbox, making it as good as new. The trim on my house remained a defiant oyster white, just as Ginsberg the gnome resumed his stoic watch over my rose bushes. Life was good. Then one afternoon, I received a call from the court administrator for the county's traffic and misdemeanor division. "Judge Finch," he said, "I know you're on senior status, but we've had a judge call out sick for the next month. We're in a real bind. Any chance you could cover the afternoon traffic and misdemeanor docket?" It was a common request for senior judges. We were the utility players of the judiciary. "Of course, Tom," I said. "Send me the calendar." It was on my 3rd day presiding over that docket, a blur of speeding tickets and minor shoplifting cases, that I saw the name on the list. The People v. Brenda Millwood. My heart gave a little thump. The system, in its majestic, blind, and occasionally ironic wisdom, had delivered my tormentor directly to my bench. I immediately called the supervising judge. "I have a conflict of interest with one of the defendants on my afternoon docket," I explained. "Brenda Millwood. I was the opposing party in the civil matter that led to these charges. I must recuse myself." "Understood, Arthur," he said. "The problem is, we have no one else. Judge Allen is sick, and Judge Smith is on vacation. If you recuse, the case gets continued for another 6 weeks. The defendant is here with her attorney. Can you, at the very least, handle the arraignment? Or perhaps see if they've reached a plea agreement with the DA." This was a gray area, but a manageable one. I could, with full disclosure on the record, preside over a pre-negotiated plea. It wasn't ideal, but it was procedurally sound. I agreed. When they called her case, Brenda and a new, more expensive-looking lawyer walked to the defendant's table. She kept her eyes down. Then when I spoke, her head shot up. "Good afternoon, counsel." I began my voice, the same dispassionate, formal tone I used for every case. "I see we have a matter of the People versus Brenda Millwood." The look on her face was a masterpiece of disbelief, horror, and dawning comprehension. It was the face of a person realizing that the universe possesses a sense of humor as dark and as biting as any satire. Her jaw went slack. Her expensive lawyer leaned over and whispered something to her, and I saw her shake her head as if trying to wake from a nightmare. "Let the record show," I stated clearly, "that I was the defendant in the civil litigation from which these criminal charges arose. I have disclosed this to both the supervising judge and, I trust, it is known to both the prosecution and the defense. I have been assured by the district attorney that a plea agreement has been reached. Is that correct, counsel?" The DA and Brenda's lawyer both confirmed it was. The deal was that Brenda would plead guilty to the lesser charge of reckless driving and the misdemeanor of filing a false report. In exchange, the felony perjury charge would be dropped. It was a standard deal, designed to avoid a costly trial. My only role was to ensure she understood the deal and to approve the sentence negotiated between the lawyers. "Ms. Millwood," I said, looking directly at her, "please rise." She stood, looking unsteady. "You have heard the agreement. By pleading guilty, you are giving up your right to a trial. Do you understand this?" "Yes," she whispered, her voice barely audible. "Has anyone threatened you or forced you to accept this deal?" "No, Your Honor." The "Your Honor" sounded like it physically pained her to say. "Then I will accept your plea. Pursuant to the agreement, on the charge of filing a false report, you are sentenced to a fine of $1,000 and 40 hours of community service. On the charge of reckless driving, your driver's license is hereby suspended for a period of 6 months. I paused, letting that sink in. For a woman whose identity was welded to her Escalade, this was a significant blow. However, I continued, the court is not entirely bound by the sentencing recommendations for the false report. Lying to law enforcement and lying under oath are not trivial matters. They are an attack on the very foundation of the justice system you now seek mercy from. An ordinary citizen might not understand that. But you, as a person who held a position of authority, who created and enforced rules for others, should have known better. There must be consequences that underscore the gravity of such an offense. I leaned forward slightly. Therefore, in addition to the fines and community service, I am sentencing you to 30 days in the county jail, with 20 days suspended. You will serve 10 days, beginning this Friday. It is my sincere hope that this time for reflection will impress upon you the importance of truth, accountability, and the simple courtesy of watching where you are going. Take the defendant into custody to be processed for her reporting date. The bailiff moved towards a stunned Brenda. Her lawyer was frantically whispering to her. She looked at me one last time, her face a perfect mask of defeat. The Queen of Oakhaven had been checkmated. As the bailiff led her away, I struck the gavel. Next case, just another day on the bench. But as I drove home that evening, past my solid, steadfast, and thoroughly vindicated mailbox, I allowed myself a small, satisfied smile. Justice, much like a well-built brick structure, doesn't bend.